Hello and welcome to episode 26 of The Legal Scoop. I'm your host, Brendan Shannon. I'm an associate attorney here at LOMAD. I'm joined today by my esteemed colleague, James Cousins. Say hello, James.
Hello.
If you're new to the show, this is our webinar series where we discuss recent wins here at LOMAD. Sometimes it's attorney wins, sometimes it's staff wins. But we do a lot of winning here and we like to talk about those. So today I'm joined by James to talk about, from what I understand, a hearing loss claim involving the matter of Patalan decision. Is that correct?
Oh, that's absolutely correct, Brendan. So I guess, I wanted to start off by saying that I know that our host, Brendan Shannon, is a big proponent of the Patalan case. He uses it a lot. And I wanted to take some time to talk to you all about how Patalan really does have a place in hearing loss claims. We always do sort of treat hearing loss claims a little bit differently than other OD claims. It has its own section of the statute. It has its own specific regulations. It's sort of unique, but Patalan still applies. And the principle actually from Patalan has sort of been in place in hearing loss cases a little bit longer. But as I'm sure you've heard from other guests on this show, that, Patalan really gave it to us in a nice, clean, crisp, few sentences about what a doctor really needs to know to identify distinctive features of employment that bring about the contraction of an occupational disease. So we just recently had, for a long time, we've had spate of hearing loss claims with particular clients too. And it's just so common throughout the course of these claims that the treating otolaryngologist really only sees the claimant for 15 minutes. And the claimant's providing the doctor a history of sometimes 30 years worth of employment history, and tries to give that to the doctor, and the doctor uses that to say, well, there's evidence of occupational hearing loss. And of course, our new usual suspect, given the retirement of Dr. Nabi here in Western New York, is now Dr. Danziger. And, what ends up happening, and what happened in this case that we're going to talk about today, is that the doctor did get a very sort of general history of an employee who had worked approximately 27 years at the same employment. And over the course of that time had worked at various positions, various jobs. It was a manufacturing facility, but this is not a manufacturing facility in the sense of like a Ford stamping plant from the turn of the century. This is a manufacturing facility that's more akin, I always say, to an iPhone. It's modern, it's state of the art. It has outstanding CNC equipment in it. It's incredibly safe. And it's also safe for employees' hearing. So you get these sort of generic statements from the doctors, and then after taking about an hour and a half of testimony with, of course, a lot of prep in advance, we come to learn that this employee had worked at various positions, but a lot of them were in quiet places like inspection rooms where they're doing non-destructive testing, where they're checking dimensions. These are like clean rooms functionally. And then we also come to find out that the employee, and about 10 years into his employment, had become a union steward and then become a union committee member, which meant that he was allowed to spend up to 6 hours a day off the floor, not doing job duties associated with manufacturing or production.
Wow.
Which the doctor was entirely unaware of. So what you end up getting from this hour and a half of testimony, which is, the claimant saying what they did, us spending a lot of time clarifying what that actually means, and picking out all the little, I call them the fishing lies. They once caught a fish this big, and every time the story is retold, the fish gets bigger. Well, once you start to call them out, and as a good attorney, once you recognize what is a lie and you can sort of let the witness know that you know better, they start to tell the truth. You take all that testimony and you throw it at the doctor. What did you know? Did you know this? Did you know that? Did you know this? Did you know that? And the doctor, unfortunately, fortunately for us, but unfortunately for the doctor and the claimant, has to admit they didn't know these things.
Right. I mean, it's not documented.
Right. And it's not even necessary to ask the ultimate question, which is, would that change your opinion? All you have to do is demonstrate that you didn't know all this stuff. The court and Patalan takes by reasonable inference. If the doctor doesn't know this stuff, the opinion has to be speculative.
Right.
And that's all we're going at. And it works on hearing loss claims, and it's worked several times. Patalan has become sort of that wonderful prime citation, which I love the case law citations.
Yeah, and we've talked about that case on here a million times, but just as a reminder to anyone watching this, the idea of Patalan with a physical injury is that if you have what's known as an occupational disease or repetitive use injury, the doctor has to very, very specifically and with a lot of detail document the job duties and the time spent performing them, that and then link them to the injury that's being claimed. So what James is saying is that in a hearing loss claim, it's no different, and in fact, it could even be easier to prove that because, generally speaking, you would agree, James, that like you said, hearing loss claims encompass an entire career, ostensibly, of injurious noise exposure or
alleged injuries.
Yeah, alleged noise exposure. So if you can attack that by showing that there's really not a lot of detail in this doctor's report and that they really didn't know all this stuff that came to light during the testimony, it can't be established under Patalan. And then I'm sure there's also plenty of hearing loss just related claims or cases that you could cite as well.
Well, yeah, I mean, there's appellate division law, that goes back 10 years, disallowing them from the appellate division, affirming disallowances where the description of noises or alleged noises was insufficiently detailed to make any sense, where there was any rational link between the allegations of the noise levels and, of course, the resultant hearing loss. And of course, this is not, it's science, but from the manner of causation, it's more of an art. So it's not a science. The doctors really do have a hard time being able to explain, for example, how a claimant could have an asymmetrical hearing loss without any indication that there was an asymmetrical source of noise in their work environment, right? Mm-hmm. That's a very common example. But what's also very common, and what was really key in this case, is the allegation that, for example, they worked 5 or 6 days a week for 27 years exposed to noise. Then you come to find out, well, their 8-hour shift really wasn't an 8-hour shift. The noise levels, particularly if you can measure them, and if the employer has good safety programs in place, the noise levels just simply aren't sufficient.
Unless we're in protection.
Right. Unless your dose is, a 10-hour dose at the OSHA threshold or at the NIOSH threshold. This particular claimant failed because the doctor just had no idea that there were chunks of time, 2 years, 3 years in a row several times over the course of his career where he was removed from exposure. The only time he was ever doing anything that was in the plant was walking to and from his clean room. And then you attack the premise that even in the plant, it's not injurious.
Not that loud. Right.
Yeah, it's not that loud. This isn't like a dystopian smog-filled, giant stamping plant. This is modern manufacturing, which is typically most manufacturing that goes on in this country now. Mm-hmm. Heavy manufacturing left in the 50s, 60s, and 70s. What's left is medium and light and specialty. So there's just no room for error, but that requires really clear investigation. It involves an attorney-client relationship where the attorney has to be intimately familiar with the client's processes. It's not enough to just know your client contact. You have to know what your client does, what their business is, and how they do it.
So would you agree that advice to any adjusters or clients who are watching this that might have hearing loss claims would be to reach out to their point of contact to see if they have any of this type of information documented, whether it be, like you said, OSHA, sound measurements, audiograms. Some employers do annual audiograms.
It's the interesting part about doing workers' comp is we intersect with so many areas of law, and one of them is OSHA. All of these manufacturing facilities are subject to basic OSHA regulations about noise monitoring, sound level monitoring, which is essentially industrial hygiene. Is it safe? It's the same thing as putting guards on sharp machines, right? You have to protect the employee from physical hazards. Sound is a physical hazard. And so if you have a client that's working in this sort of industry, you can expect, and they should have, some kind of OSHA testing going on. The question is, can you use it for evidentiary purposes? But even if you don't have that, at the very least, what you can do is instruct your counsel, allow your counsel to become familiar with who the client is, who the employer is, what do they do, how do they do it, how does this work? Because if we are armed with information, and this is true in any case, if we're armed with information about what a claimant does, right, on a daily basis that is objective and that is supported by supervisor information and coworker information, we can try and do our best to keep that claimant honest during testimony. And
right.
that is almost always the best thing that we can do. Honest testimony, when we file the C7, we've recommended a C7, will usually get you a positive result on the case.
Absolutely. So I take it you won this case. Congratulations on that. I think that's a great win and a great illustration of how you can be creative with case law. So, like you said, in this case, Patalan pertains to physical occupational disease, repetitive use claims, but it can be easily applied to hearing loss claims. If you would like to see more videos like this, we have Melanie Daly's series, as well as, I believe, Andrew Gould's Ebenezer Scrooge series this month. Please subscribe to our YouTube channel below, and we'll be back next month with more wins for episode 27. Thank you.
Thank you, Brendan.